Florida, 1996. Teenagers drank blood, called themselves immortal. But their play became ritual, and their ritual became murder. Rod Ferrell's clan, the children who chose the coffin.
In 1996, a teen calling himself Visago, a 500-year-old vampire in his imagination, led a clan bound by blood rituals and gothic fantasy. Their play acting turned deadly on November 25th in Eustis, Florida, when two clan members bludgeoned Richard Wendorf and Naoma Ruth Queen to death with a crowbar. The victim's daughter Jennifer found the scene, while suspicion quickly fell on her sister Heather's ties to Rod Ferrell and his so-called vampire clan. What followed was a lurid collision of teenage fantasy, brutal violence, and landmark legal battles. Headlines screamed vampires, but the courtroom saw only murder indictments, plea deals, and precedent-setting rulings. Teenaged fantasy collides with real-world violence. Rod Ferrell, a Kentucky teen who shuttled between Kentucky and Florida, created a vampire persona called Visago, casting himself as the immortal brooding leader of a teen clique. The teenagers experimented with ritualized blood consumption and gothic aesthetics. This was widely documented, not media exaggeration, but in truth. It helped elevate the story to national attention. But the real crime was not symbolic. It was brutally physical. In the Wendorf home, Ferrell and accomplice Howard Scott Anderson entered through an unlocked garage, grabbed a crowbar, and bludgeoned Richard Wendorf, who lay on his couch, to death. Naoma Queen, surprised by the intruders, suffered the same fate. The other teens, Charity Kesey and Dana Cooper, drove Heather away and were not physically present during the murders. Afterwards, the group stole the Wendorf's Ford Explorer and fled south along the interstate. It was a desperate, terrified road trip rather than a cinematic escape. Gas stations, back roads, and motel stops. Days later, a concerned relative notified authorities, leading to their arrest in Baton Rouge, Louisiana. There were no supernatural chases, just competent policing and a worried grandma. How Vampire Clan became court reality. In the weeks after the shocking murders in Eustis, Florida, the legal system moved swiftly. Investigators built their case around the teenagers who had fled the state in the stolen Ford Explorer, and a Lake County grand jury handed down indictments. 4 names appeared: Rod Ferrell, his close friend Howard Scott Anderson, and 2 other companions, Charity Kesey and Dana Cooper. They were all accused of serious crimes ranging from first-degree murder to burglary and robbery. Noticeably absent from that list was Heather Wendorf, the younger daughter of the victims. Despite the rumors swirling through the community that she had somehow orchestrated or encouraged the killings, 2 separate grand juries refused to indict her. For prosecutors, the decision was based on evidence, not speculation. There was no proof that Heather wanted her parents dead, and without hard facts, the case against her evaporated before it could begin. Meanwhile, the press latched onto the story with gleeful abandon. The image of black-clad teens drinking each other's blood and swearing allegiance to an imaginary vampire leader was tailor-made for headlines. Tabloid shows and nightly news segments branded the case as the vampire cult murders. Yet inside the courtroom, the atmosphere was much less theatrical. Prosecutors stripped the story of its gothic costume and focused on what really mattered in law: unlawful entry into a home, the brutal use of a crowbar to kill 2 unsuspecting adults, and the theft of property afterward. The legal process didn't hinge on whether these kids believed they were immortal. It hinged on the fact that 2 people were dead, and someone had to answer for that. A death sentence for a 16-year-old, Florida's youngest on death row? When the case reached its climax, the focus inevitably fell on Rod Ferrell. In 1998, facing a mountain of evidence and the prospect of a drawn-out trial, Ferrell pleaded guilty to 2 counts of first-degree murder, as well as burglary and robbery. What happened next shocked even seasoned observers of the justice system. A Florida jury, after hearing the details of the crime and considering the brutality of the killings, voted unanimously 12-0 to recommend the death penalty. the trial judge, following their recommendation, imposed the ultimate punishment. Ferrell was just 16 at the time of the murders. That made him, for a time, the youngest person on Florida's death row. The image of a teenager condemned to die by the state added another layer of morbid fascination to a case already drenched in sensationalism. The courtroom spectacle collided with broader questions about juvenile justice. Should someone barely old enough to drive be subject to the same capital punishment reserved for hardened adult killers? The law said yes in 1998, but even then it made many legal scholars and child advocates uneasy. In hindsight, that uneasiness proved well-founded. The United States would soon embark on a years-long rethinking of how the justice system treats juvenile offenders, and Ferrell's case became an early example of just how uncomfortable the death penalty looked when applied to adolescents. Florida Supreme Court intervenes. By the turn of the millennium, Rod Ferrell's status as Florida's youngest death row inmate was already sparking legal and ethical debate. In November 2000, the Florida Supreme Court took decisive action. Drawing on its own precedent in Brennan v. State, the justices concluded that sentencing a 16-year-old to death was unconstitutional under Florida's ban on cruel or unusual punishments. With that ruling, Ferrell's death sentence was vacated and replaced with life imprisonment without the possibility of parole. It was a stunning reversal, not because the court doubted his guilt, but because the evolving legal landscape recognized the profound differences between juvenile and adult offenders. Ferrell's crimes were brutal, but the state's highest court made clear that putting someone to death for actions committed at 16 crossed a constitutional line. The timing was significant. The U.S. Supreme Court had not yet weighed in on the matter. It would be another 5 years before Roper v. Simmons, 2005, established a nationwide ban on juvenile executions. But Florida's ruling in Ferrell's case foreshadowed that outcome. In a sense, Ferrell's trial and sentencing became a bellwether for how the country would rethink the ultimate punishment when applied to adolescents. For legal scholars, it was a pivotal moment. For Ferrell himself, it meant the state would not execute him, though he still faced the prospect of dying behind bars. The vampire persona had long since evaporated in the harsh reality of prison life, but his name remained tied to one of the most consequential juvenile sentencing decisions of that era. Miller, Montgomery, and resentencing for juveniles. Decades later, a new wave of legal standards swept into juvenile sentencing. The U.S. Supreme Court's Miller v. Yes, Alabama, 2012, ruled that mandatory life without parole sentences for juveniles violated the Eighth Amendment unless extraordinary circumstances were demonstrated. Montgomery v. Louisiana, 2016, made the Miller rule retroactively applicable. Florida responded with remands and resentencing for cases like Ferrell's. In December 2018, Howard Scott Anderson underwent resentencing and received a 40-year term with credit for time served, making possible his release in the early 2030s. Ferrell's 2020 resentencing: irreparable corruption or transient immaturity? Rod Ferrell's resentencing hearing, held across 2019 and early 2020, featured live testimony, psychological evaluations, and victim impact statements. In April 2020, Judge G. Richard Singletary drew a line in the court record. Ferrell's crimes reflected irreparable corruption, not mere adolescent immaturity. As such, the judge upheld his life without parole sentence. This grave verdict wasn't about his teenage fashion or blood-drinking theatrics. It was about gruesome domestic murder and unrepentant mindset. In legal terms, Ferrell didn't qualify under Miller's protective rubric. His sentence stands under modern juvenile jurisprudence. Where they stand today. As of 2025, Ferrell is still incarcerated in Florida, serving life without parole. Meanwhile, Anderson's resentence term, 40 years with credit for time served, positions him for possible release in the 2030s. Cooper and Kesey, the teens who took Heather elsewhere and weren't in the house during the killings, pleaded to lesser charges, served finite sentences, and have since been released. Heather Wendorf was never charged. Beyond the sensationalism, the courts meticulously sorted who belonged in prison and why, based not on myths but on criminal actions. And that's the unbelievable yet very real story of Rod Ferrell and the so-called Vampire Clan. If you found this deep dive fascinating, don't forget to hit that like and make sure to subscribe. Thanks for watching, stay curious, and remember, sometimes the scariest monsters aren't in horror movies. They're sitting right next to you in homeroom.
They believed they were vampires, but prisons are stronger than fantasies, and the only eternity they found was behind bars.